Thank you very much. Good afternoon, everybody. Thank you very much for registering to participate in this FSR webinar debate on the GB capacity market standstill, what is happening and why. We have two discussants today. One has already arrived in the studio, Professor Jacques de Rennes, who is at Shepherd de Moulin and based in Brussels and also at Liège University, and a very well-known expert in the field of state aid. And he is very closely involved in the case. He is in fact representing Tempest Energy in this case, and is also involved in other capacity market mechanisms cases that are reaching the courts as we speak. So we're in very good hands today. And I think we should maybe start off then with Jacques maybe introducing a little bit of background of the case. I'm sure many are aware of the importance of this case. It's the first opportunity that the European Court of Justice will have to review arguments from the Commission in the light of the General Court annulling one of its first decisions on the legality, on the compatibility of capacity market mechanisms in its decision shortly after the new guidelines came into force in 2014 on the UK capacity market.
Your sound is a bit cut off, Lee. Sorry.
Sorry, can you hear me now?
Better, maybe.
Is that better?
Yes.
So it took that decision, the Commission took that decision having only conducted a preliminary investigation. And that is one of the reasons why, of course, the General Court has annulled the Commission decision. The Commission should have, in its view, opened a full investigation. And I think Jacques will tell us where we are now in the procedures that the Commission has done since the annulment of its initial decision. And he will tell us about what's going on in the UK market and the steps Tempest Energy has taken with regard to suspending the collection, the levy pays for that finances this capacity market mechanism in the UK. Jacques, over to you then to give us a bit of background. Thank you.
Yeah, thank you, Lee. So happy to be with all of you. And of course, as mentioned by Lee, since I'm acting on behalf of Tempest Energy in those cases, I need to be quite reserved on what I should say. There are ongoing procedure. The Commission is not in this discussion as a presenter as well, so the purpose is not to continue or to re-debate what we have said to the court, General Court and the Court of Justice now, since, as you know, the judgment of the General Court has been appealed by the Commission and the return procedure is progressing only. So I propose to start with first to have an introduction about what is DSR and what does Tempus do specifically and contribute to the market and why did they bring this action. So Tempest Energy is a clean tech startup group focusing on electricity demand side response, DSR, which was originally developed to ensure the continuous balance between electricity supply and demand, the electricity system, and such balance was required to prevent frequency loss, as you know, the blackouts, regardless of demand levels. DSR enables TSOs to increase capacity on the network by asking the demand side, the energy customers, to temporarily shift or reduce peak energy demand in return for payment. And this helps to avoid or at least delay costly energy procurements and network upgrade investments, which would otherwise be needed to cover the hours of peak electricity demand, the demand spikes. As variable resources such as wind and solar provide an increasing proportion of intermittent generation to the grid, new forms of demand response are being developed, in fact, with capabilities that surpass the traditional peak load reducing demand response. Tempus has developed a technology that is able to manage the electricity usage of customers with flexible load, and that technology uses algorithms and automated DSR technology to shift usage away from expensive times of peak demand into times when energy is cheap and plentiful, such as periods where there is an excess of wind powers, for instance, on the system or during the night. This allows more cost-effective electricity purchases on customers' behalf without the customer needing to actively manage their appliances or track energy prices. And it also has the wider benefit of enabling renewable energy to be utilized where possible. So Tempest's mission is to remove artificial price barriers from the electricity market, bringing transparency and connecting customers with the cheapest available energy. So coming back to the case, so that's what Tempest does and what DSR contribute to the electricity market. The reason for the case, as mentioned by Lee, against the Commission's decision of 2014 was simply the protection of procedural rights of Tempus, according to Article 1082 of the treaty, TFU, and Article 44 and 61 of the procedure regulation, which has not changed since the new regulation in the numbering and the substance. The Commission is in principle obliged to initiate a formal investigation procedure if it has doubts on the compatibility with the internal market of a state measure, notified or not to it. And in this case, Tempus chose not to challenge the decision of the Commission on its merits, because it would have been probably inadmissible to do so. You have, as you know, to show that you are substantially affected in your competitive situation and to challenge the substance of the decision, i.e. the exemption by the Commission, and to show that the Commission made an error of law on the exemptions. Instead of that, according to the case law, Tempus, as an interested party, was admissible to protect its procedural rights, i.e., since Tempus considered that the Commission should have considered that it had doubts about the quality, it should have been obliged to initiate the procedure, the formal investigation procedure, and then it's only on the existence of doubts on the compatibility that the action was made, and that the General Code agreed to that application and annulled the decision. So the annulment of the decision is not an annulment on procedural grounds only. It's a mixture of, indeed, a process that the Commission should have followed, opening the investigation, since it should have had doubts according to the General Code, but the examination of the substance was made to the extent necessary to show doubts. So it's a lower standard, of course, than to show that there was an incompatibility or compatibility assessment. This is not an exceptional judgment. In the recent months or years, the General Code annulled in the past other decisions of the Commission not to raise objections, i.e. to accept the compatibility of a measure without initiating the formal investigation procedure. And I can refer you to a judgment of 15 October last year in T7916 VGG, and in December, 13 December last year, the Scanlines Denmark case T630/15, which are appealed as well. At least the second one is appealed as well. So basically, the principle which will be developed in the following are that if doubts exist, the Commission must initiate investigation. So all the discussion will be are doubts there or not. And 3 points about the doubts. I will get back to that when examining the General Court judgment, but the concept of doubt is exclusive. The Commission is obliged to do something if there are doubts, and the concept is objective, i.e. Subject to full judicial review. And to challenge the lack of opening of that formal investigation procedure, third parties like Tempus or others bear a burden of proof of the circumstances and the length of the phase leading to the decision. That's on the one hand, and on the other hand, they should discuss the content of the contested decision and to show that the Commission had not researched or examined thoroughly or impartially all the relevant information, or that it had failed duly to take them into account, and then not follow this obligation following the doubt. So, voilà, that's a bit the introduction I could make about Tempus, the case, and the judgment.
Thank you very much indeed. That was very, very clear. I'm afraid we're still missing our colleague from Frontier. We're trying to locate him. Jacques, you said maybe a legal point on this type of procedure, that it's sometimes very difficult in these types of cases where you're challenging the failure of the Commission to open the full investigation, not to get into the merits of the case, because the court has said in the past you're not allowed to argue the merits, that you have to wait until the full procedure. What you're challenging is the failure of the Commission to protect your procedural rights. And one of the things I think that's very interesting in this case is that there was a very long pre-notification procedure where the Commission had contacts with various parties, but the General Court didn't seem to think that was relevant. On the contrary, the General Court seemed to think that the very length of the pre-notification procedure should have underlined the fact that the Commission had serious doubts in this case. Is that, do you think, a fair summary of the ruling?
Yes, I can go into more detail, but just two points on that. The first on the examination of the merits of the case, the substance. As I said, if an applicant chooses to challenge a decision of the Commission only to protect its own rights, the fact that it had the right, if there were doubts, to have an initiation of the formal procedure, in that situation, at least the case law accepts that you raise a minimum of facts, a minimum of legal assessment to show that the situation was raising doubts. So the discussion is limited by that, but it is agreed to have a discussion, and the Commission and the applicant and the court had that discussion on the substance of the case to the limit necessary to show that or not that those circumstances, those issues should have raised doubts. So to that extent, if you play the game well, i.e. do not claim to challenge the substance of the decision, but only the fact that the Commission had available information sufficient to show doubts, it's admissible. But there is a fine line to that, but I think the discussion with the Commission did not bring any problem on that, and the Commission did not raise any admissibility issues about this point. So your second point was the pre-notification phase. I will come back to that. This case, as probably the others, are maybe a bit new because the accent, the focus was made a bit more now on the interaction between the pre-notification phase and the preliminary examination, which is the phase 1 after notification. As you know, in the best practice procedure of the Commission in 2009, the Commission referred to the pre-notification phase and explained that it was very important to discuss legal and technical issues with the member states in order to ensure that the notification was efficient and complete. But that was paragraph 10, and paragraph 16 of that best practice of 2009, which applied to the case. It has been amended last year and increased, in fact, what I say. But paragraph 16 of that, the Commission said that it will not provide any preliminary compatibility assessment, that the purpose on its own words, the purpose of the pre-notification is not to discuss the compatibility, but to prepare the compatibility assessment in order to have an efficient notification. And in this case, at least externally, and of course we discuss much that issue, and we are discussing this issue in the appeal, of course, with the Commission, which disagrees, of course. Basically, in substance, we claim that, and we have evidence about that because there is some letters of exchanging between the UK and the Commission which show that during the pre-notification and at the end of it, there've been discussion about the substance of the case, because we have a letter which is mentioned by the court, the General Court, I think it's paragraph 68 or 69, something like that, where the General Court referred to a letter of June 2014 before notification, whereby the Commission had mentioned to the UK that, following this pre-notification phase, we believe, we the Commission, that it is prima facie compatible and you can notify. So this was one of the elements that the General Court took into account to show that there was a sort of misuse, so to speak, of the pre-notification phase, during which substance had been discussed in detail, and it is a bit strange to see a pre-notification of 18 months long, which conducted the case to be well prepared, certainly, notified, and then to have a notification of 1 month only. Usually, in difficult cases or technical cases, the notification, the preliminary examination following notification lasts far more than 2 months, and it's admissible to have 3, 4, 6, 10 months of preliminary examination, provided that the Commission can say that the notification is no longer complete, that there's still question, etc. During that time, there is a discussion of the substance. And in this case, unlike the difficulty of the case and the very long pre-notification, the preliminary examination following notification lasted only 1 month, which is extremely short. And which was an indication, among many others indication, that the procedure, the correct procedure, has not been followed, and that the decision to raise, not to raise objections, had been based probably more on an assessment of the compatibility during the pre-notification than it should be during the following notification. Well, that's the dichotomy of that, and the apparent misuse of the procedure, as we claim. The Commission, of course, claimed the contrary, that on this basis the judgment has been notably made, concluding to the fact that that was an element of difficulty. But there are many other elements which can explain with the judgment later.
Thank you very much. Can you hear me clearly? I hope without echo. I think that explained very well, some of the peculiarities that led up to the court's judgment. Are there any other aspects of the judgment that you would like to highlight now, moving on to that heading?
Well, yes, probably indeed. We can start discussing the main arguments which had been put forward before the General Court and how the court examined them, if you want. There were 2 pleas against the decision. The first plea concerned what we discussed, the violation of the procedure, the violation of Article 108.2, so challenging the fact that the decision in the decision, the Commission should have had doubts on the compatibility and should have initiated the formal investigation. And to show that serious difficulties, doubts, arose in relation to the capacity market scheme as notified, and that the Commission should therefore have doubts, Tempus raised following series of points, which I can list it now without explaining them in detail yet. First, the Commission failed to properly assess, according to Tempus, the potential role of DSR in the GB capacity market. Second, the restrictions on the duration of DSR contracts under the capacity market violated the principle of judicial expectation and non-discrimination, wrong assessment of facts as well. Third, the requirement for DSR operators to choose between transitional and enduring market auctions was also contrary to those principles. Fourth, the capacity market's cost recovery methodology was against those principles as well of non-discrimination and proportionality. Fifth, the use of open-ended rather than time-bound capacity agreements in the enduring auctions was contrary to those principles. Little f, the bid bond requirements to obtain access to the auctions was a problem as well. And finally, the lack of additional remuneration for savings in transmission and distribution losses from DSR was also a problem. This last point was rejected by the court. The second plea, that's the first plea, all the elements of doubts, and the second plea was a failure to provide adequate reasons in the decision, that plea had not been examined by the court since it's focused on the first plea. Well, that's a resume of the pleas in law, and I can go into the detail of the judgment if you don't have any question right now. Please, I see that Dan is there now.
Thank you very much. I think maybe we will, now that you've finished with the resume of the judgment, we can switch to Dan. Welcome, Dan.
My apologies for a slight delay. Time zone fail.
It can happen. At least it was only a 1 hour time zone difference, I think. So we were able to catch up. So, Dan, from Frontier Economics, you are looking closely at the consequences of the ruling on the UK market, what has happened since the ruling was handed down and the scheme has been suspended. Maybe you could bring us up to speed on some of the factual elements and the consequences of the judgment.
Sure. So, well, clearly the payments to generators and other capacity providers have had to stop as they're now qualified as non-lawful state aid. The impact on the energy markets themselves is quite difficult to. The short-term energy markets is quite difficult to pull apart. There have been a number of commentators that have talked about forward prices spiking as soon as the announcement was made. But I think in reality, you look at GB forward prices; they're principally driven by gas and short-term asset information. And I think if you try and isolate any one cause of changes in prices, you could just as easily have seen expectations of gas move, short-term gas prices move, what have you. So I think it's actually in reality quite difficult to say whether there's been any impact on short-term markets. Indeed, obviously we are now pretty much, at least if I look at the weather outside the window, through winter 18-19, and the security of supply situation always looked like it would be okay for that winter anyway. I guess the real question revolves now around the next winter and whether the arrangements are, or an arrangement is capable of being put back in place for that. If it isn't, then clearly there are older existing plant who would be losing a revenue stream and therefore potentially thinking about their future. There may be some new build that hasn't yet fully committed to its build out that may now be thinking, well, actually, I can. This is a way out of my contract, potentially, if it was any way out of the money. So I think the attention is really on next winter and whether the legal and administrative processes will permit the government to reinstate some form of mechanism prior to us entering that winter in order to, if you like, secure the capacity margin. We were due to have a what's called a T-1 auction, so a very short-term auction to finish off the capacity, to buy up the last bits of the capacity that we needed to go into winter 2019-20. I think we're about 5 gigawatts short. So really, what I guess is important for that very short-term future is that some mechanism can be put in place to secure that residual capacity for the forthcoming winter. That's probably the focus of short-term attention.
Thank you very much for coming up to speed so quickly, and I think you really had to. Sorry, you got dropped in it with the time zone difference. So we're correct to say that all the options, the T1 and I believe the longer term T4, everything's been suspended.
At the moment, we're at a status where none of the auctions can be held because none of the payments pursuant to the existing contracts and none of the new auctions are being held pending resolution of the administrative and legal issues. I think there is still an idea that if this can be sorted reasonably quickly, we were due to have a T-1 auction sometime early this year to buy this, as I say, this last 5 gigawatts. You could probably just about get a T-half auction held sometime this summer. And this 5 gigawatts is probably largely existing plant that's on the system as we speak. So to secure that continuing through winter through a T-half auction, so half a year ahead of delivery rather than 1 year ahead of delivery, would just about be possible. And I think that's certainly an option that if the thing gets resolved relatively quickly on the legal front, something that people will probably look for.
Thank you very much. I think then going back, that's a good point of departure to go back to Jacques. If we go and look now in the judgment, are there grounds for optimism that we can resolve this situation quite quickly, or has the judgment knocked the legs under the UK system?
Yeah.
So maybe
of course, it would require us to explain what is happening before the National Court in the UK as well. I will come back to that, although it's an ongoing process. But I would not spend too much time on the description of the judgment because everybody can read it and have a look. It's very complex and long, but you know now what is the result and what is basically the reasoning of the court. I can come back to that later, but following an examination of the plea of Tempus about the infringement of Article 1082, they examined the concept of doubts and whether the decision of the Commission not to initiate formal investigation was correct or not. They interpreted the concept of doubt according to the case law, mentioning, as I said to you, it was exclusive, objective, and subject to judicial review. And that Tempus had the burden of proof to show a body of consistent indication concerning further circumstances and the length of the preliminary examination procedure, and second, the content of the contested decision to show that the Commission had doubts. I will skip that part and go to the end of the judgment, just to mention that the judgment referred notably, among other elements, not only to that, to the significance of the case, the amount of the aid and the amount of the auction as compared to the whole market, the complexity of the situation and the numerous situation managed by the capacity market and probabilities, different categories of operators affected, the various auction mechanisms involving a number of stages, the complexity, the novelty as well, and they compare to these circumstances to the reaction of the Commission. And they say the pre-notification has been very long. You asked constantly questions until the end of the process without getting all the responses, and you still were asking questions when the notification was made. And you run a national public consultation in 2013, but it was not relevant since it was not managed by the Commission. It was the member state cannot substitute with a national public consultation a proper formal investigation by the Commission. And there were complaints by 3 types of operator at the end of the process, after notification and just before, a provider of balancing services. They were DSR people regrouped into the UK Demand Response Association, commented before notification, and after notification, another operator who had acquired an existing power plant complained as well on a few difference of treatment. So altogether, with that situation, at that stage of procedure, the General Court, noted that the Commission, on the verge of starting this examination, did not examine and ask more information and satisfy itself with all the information provided by the state without challenging them, in fact. And consequently, the length of the discussion, the circumstances surrounding the adoption of the contested decision, the notify measure, which was significant, complex, and novel, the fact that it gave rise to a long pre-notification phase with a number of questions on important matters, the fact that the notify measures were challenged by various operators, the fact that the Commission did not conduct any specific additional investigation on its own, all that was sufficient for the court to agree with Tempus that they were dots. They should have been dots. And then the fact that the exemption was given without investigation was should be annulled. And I skip all the detail of the judgment. We cannot go to that detail now. It should be too long, but you can see the conclusion made by the court, and the court went into the assessment, not only the circumstances, but in the second part of the judgment, assessed the way the Commission examined the role of DSR within the capacity market in the light of the available information, the equivalence and advantages of generation and DSR, the positive role of DSR, the available information of the potential of DSR, and examine notably the length of capacity contract, the capacity market's cost recovery methodology, the conditions of participation on the auctions, all that technically pretty much examined by the General Court, and concluded that the Commission should have initiated the formal investigation. So what's the resulting impact? The decision was annulled, which means that the decision is deemed to have never existed. That's the legal fiction. In law, in EU law, the decision has been annulled. That means that all payments, all capacity agreements, everything which has been made after the decision in 2014 are deemed to be illegal. That's the law, because they are not covered by an exemption decision. And that's which is admitted by everybody. This is the result of the retroactive effect of the annulment of such an approval, which means that there is a recovery aspect. I will come back to that. And in the meantime, the standstill obligation of the UK is to maintain the situation as it is and not to grant anything, or at least not to take steps which could be deemed to be new state aid until the Commission approved the notification, which is still pending, and probably decide that there are certain modalities to be redesigned. In the meantime, of course, the Commission has lodged an appeal, in January against this judgment of the General Court. The appeal is not suspensive, and the Commission did not ask to suspend the execution of the General Court judgment. This means that the decision is still fully annulled until the Court of Justice annul or not the judgment of the General Court. And until that decision, the Commission was obliged to take consequences of the annulment and open investigation, which the Commission did in February, as you know. So I will come back to the four issues which are before the judicial review in the UK. But in the meantime, I'll stop there if you have any questions, if you want to take any questions, Lee.
I think we'll keep questions till the end,
yeah.
But maybe we could just briefly switch over to Dan. Maybe just give him the opportunity to say something in relation to the non-judicial proceedings in the UK. Presumably the department involved, the BEIS, is looking at redesigning the auction mechanisms. Indeed, I think, if I'm right, it conducted, even before the scheme was annulled, it was conducting consultations because it was concerned with that many aspects of the scheme as originally designed were maybe not functioning in the way that it had hoped. And yet it put a great deal of work into designing the scheme. So do you think that they're going to have to overhaul it dramatically? I mean, from an economist's point of view, do you think that the role of DSR could be improved in a future scheme?
There's probably a number of points there. I guess in relation to the change of modalities and the sort of to anything changing which isn't prospective, I think the government will be quite anxious to avoid it. And indeed, if you look in the letter which the EC wrote to the UK government, the kicking off the reconsultation, as it were, I think you can read between the lines in there some sort of hints that maybe if you change some things going forward, we might be able to find a way of assessing this scheme as being okay. And I think there's quite a strong logic for that, because if you say, okay, the scheme as is with some prospective changes is fine, is state aid compliant, then what can happen is all of the outcomes essentially from the auctions that have been held to date can stand. If you go and change a part of the design of the scheme retrospectively, if that is a condition of the second clearance attempt, as it were, then if those are significant changes, then clearly the results from the auctions that have been held are unsafe in a sense, because if you change part of the design, presumably the outcomes would change. So you would almost need to rerun those auctions, and that would clearly create more disruption. So I think probably an important part of what the government would like to get out of this is, if any changes have to be implemented, that they are prospective. In other words, that the mechanisms given clearance historically as was, and prospectively with some changes. The government had, at the point the mechanism was implemented, the government had committed to undertake a review of the arrangement 5 years in. So I think they had already kicked off a process to assess whether it was functioning appropriately, just as part of normal kind of good practice to keep major policies under review. And I think that's maybe the process that you'd referred to, Lee. I think from a perspective of is it working? You know, if you didn't have the legal issue around the EC not having conducted its investigation, if you just sort of asked the GB government are you happy with this, the way it's going? I actually probably think that they would not give you too negative an answer. There have been increasing, well, for a start, the prices in the auction have been very low. The auction has bought from a situation in 2014 where we were tight on capacity. It's brought the system to a point where it has a much more secure situation, and if you like, some of the distortions which were observed in the earlier auctions, particularly the purchase of lots of very small engines to provide capacity, the distortions which led to those outcomes have been addressed in other aspects of what the government and the regulator have done. So I think if you ask them on balance, they'd say, this has been relatively cheap. It has delivered capacity. We have seen a mix, an increasing mix of DSR coming through in the auctions, notwithstanding the points that Tempus has made. So I think if they didn't have, if there weren't an impetus coming from this legal process, then probably the government would be conducting a review, but wouldn't be looking at major change. I think the one area of change that has sort of maybe homegrown, as it were, that they would be looking at, absent any of this, would be currently renewable sources are excluded from the capacity mechanism, and that arguably creates some distortions between different types of technology, and they may be looking at including renewables in it in some way. But I think you're probably talking about that sort of more marginal change than a fundamental redesign absent the legal proceedings.
Thank you very much. Thanks for that. That was, I think, a very clear exposition, perhaps, of the risks that the government might take if they decided to do anything fundamental, given what's going on the legal front. And there's, of course, still a lot going on. We have the Commission has reopened proceedings and proceeded to the formal investigation. We have a challenge from the Commission to the Court of Justice. And then we also, of course, have national proceedings going on. And that all relates to, if you like, to the past, to the scheme as it was in 2014, as it was then conceived. So perhaps, Jacques, you would like to take us back to that part of the scheme, or that stage of the scheme, and describe in some detail what's happening now, the impact of the annulment decision and the UK court proceedings.
Yes.
That Tempus.
The situation is not only for the past; it's for what is currently done by the Secretary of State for the time being. In fact, the most of the issues are in the meantime, until the Commission would be able to decide on the substance again. There are a lot of legal issues whereby all third parties legal rights are put at risk, in fact. And there are four issues which are put forward before the High Court for the time being. I will explain in a nutshell, very simplistically, of course. And I will explain first the issues before the argument. So the first issue is the replacement T-1 auction. As you know, BIS has decided to hold a T-1 top-up auction during the summer of this year, replacing the auction which would otherwise have been held in January this year in absence of the judgment of the court. It relates to the delivery of the next winter. And this replacement T-1 auction has the following features. The first feature is that the successful bidders, so it is happening now, would be granted conditional capacity agreements immediately after the auction, which will be converted to regular capacity market agreements upon stated approval, expected, hopefully, by the Commission in the future. This would have no discretion over whether to convert these conditional capacity agreements in the event of stated approval being granted, and there will be an automatic trigger to convert the conditional agreements into regular capacity market agreements in order to provide additional certainty to bidders. Secondary trading of those conditional capacity agreements has been permitted immediately after the auction, with no need to wait until the further stated approval, if any. And I would stop there. That's the replacement T-1 auction. Second issue is the continuation of the existing agreement with deferred payments. BIS has decided to continue to enforce the existing agreements and to make deferred payments once stated approval would be obtained. It has taken the decision that existing agreements holders will not be permitted to voluntarily withdraw from the capacity market agreements that they signed during the standstill situation we are in. Those agreements will continue to be administered and enforced in the usual way, raising for penalties and obligations, etc. But at the same time, since the secondary trading has been granted, those agreements have some value. The third point is the continued collection of the monies to fund the supply charges. Payment to the capacity market agreement holders are funded by the supplier charges, as you know, which in turn are funded by charges to the customers. And BIS has decided that suppliers can and should continue to collect monies from their customers during the standstill period for the purpose of meeting the capacity market supplier charge in the future. They also decided to enable but not require the collection of those monies from the suppliers by the electricity settlement companies. And the last point is the past. The last issue is that from what we have seen, at least implicitly, and from any statement by the UK government, there's been no suggestions that the aid which had been unlawfully implemented since there was no exemption, since the decision was annulled with retroactive effect, no suggestion that this aid which had been unlawfully implemented should be recovered. No suggestions of requiring capacity market agreement holders to refund the monies received. No suggestion of reimbursing customers who funded the unlawful aid. So Tempus took that stance as that BIS must have presumably positively decided not to recover unlawful state aid. And it seems that the position of the UK government seems to be very at odds with the case law, because they say, oh, the Commission will approve probably, so I will not ask recovery now because it will be approved and they will regularize, which is wrong in law, because as you know, since 1991, the FNC case, that the decision of the compatibility of the Commission coming after will not regularize unlawful aid. And in between, in the meantime, the first obligation, not the power, the obligation of the courts is to immediately stop and recover state aid which had been unlawfully granted without approval. So I come back to the substance quickly to explain to you. The replacement T-1 auction is for Tempus a state aid, a new state aid, because it, in substance, I cannot detail that in detail, of course, now, but in substance, it creates a situation whereby there is an advantage which is granted, economic advantage, through the fact that this right to be in the auction and to get these conditional capacity agreement markets will be tradable, is tradable, and is an economic advantage which is granted by, imputable to the state, granted by the resources of the state, because there is a legal commitment to pay that in the future. It's like a guarantee. BIS has enabled the secondary trading to take place, and the contingent liability of the state to make those payments is what gives the conditional capacity agreement market value in the first place, enabling it to be tradable. So according to the case law of the court, there is an economic advantage which would be granted actually now for the time being, whilst the standstill obligation should command the UK state not to grant anything. The second ground is the continuation of the existing agreement with deferred payment. There again, a similar approach is made to the T-1 replacement auction and the awarding of conditional capacity agreements. To the extent that further decision on phase 2 would include those capacity agreements within its scope, the National Code is bound by that approach. And in any event, the capacity market agreements form part of the same single intervention as the rest of the capacity market. Of course, there cannot be any auction without any payment in the future, so it's the same type of measure. So the continuation of the obligation under those agreements amounts to an economic advantage, not only obligation, there is an advantage behind that. It perpetuates the privileged position of the parties to those agreements on the market, and the economic advantage is imputed to the state and granted stems from the accrual of a liability of the state to make those deferred payments in the future. So there is a qualification of aid to that, a new aid, in fact, in the behavior of the state to maintain this legal situation on the market until the Commission has decided on the substance. And according to the self-judgment, I will not go into detail of that judgment, the self-2 judgment, not self-1, self-2 judgment, until the Commission has decided, and since there is no decision of the Commission on the compatibility of the system, any new aid and any past aid should be reimbursed immediately. And if a court is refusing to do so or staying the procedure until hopefully the Commission will say it is compatible, that would be a violation of its obligation under EU law. So, and there is no legitimate expectation for beneficiaries because, unfortunately for them, they knew that the capacity market was challenged in 2015. They should have known at that time that there was a risk. They should not have invested into that. The risk has been taken by the state. And since the capacity market, although approved, was challenged, not definitely approved, therefore, although it was legally approved, but retroactively annulled. So that means that the difficult legal consequences of that is that there cannot be any legitimate expectation for beneficiaries according to the law of the Court of Justice. I'll skip the supply charges, but since it is linked to the funding of the method of financing of the capacity market, they form part of the same single intervention, and they are deemed to be also an economic advantage for the time being. And I come to the recovery, which is for the past. For the effect, as I said, of the judgment is that the Commission decision is annul ab initio, which means that applying the conditions of the case law, notably self-2 judgment, paragraph 36, there is no doubt about the classification of aid. It was notified. So it was an aid, of course. The aid was implemented. It had been paid for partly. It had been the capacity market has been granted. Payment would be made. There should be made one day for that. So the aid was implemented, and there is no exceptional circumstances arising that would make recovery inappropriate. In particular, the recipients of the aid could not have any legitimate expectation on the basis of the Commission decision, which is annulled, because an application for annulment in relation to that decision was made on time at the time in 2015. Accordingly, the High Court is obliged to order recovery of those payments, and the monies received can no longer be at the disposal of beneficiaries. Any other result would perpetuate the effects of the unlawful aid and would be contrary to EU law. There is a confusion for the time being within the UK between SELF1 and SAFE2, where there is a temptation to say the Commission will approve probably, so I will not recover now. That's a mistake, because in law, the obligation of the court and the obligation of the state is to, during this standstill procedure, to give full effect to the law, i.e. the law is for the time being, since the Commission has not decided on the compatibility assessment, is that all the capacity market is unlawful because it had been not approved, but implemented in part. So the legal consequence of that for the courts, the national courts, and for the authorities, because the authorities is the member states, the court is part of the member states, is to take the consequence of the unlawfulness of the system and to stop it entirely and recover all the advantage for the past. I understand, and Tempus understand the issues behind that, the legal uncertainty, but this is the consequence of the law and of the mistake of by the Commission and by the UK, and not for third parties to bear the consequence of that. So that's a basic, simplistically explanation of the situation. Just one word about the Commission, to be fair. Following the judgment of the General Court, the Commission was obliged, of course, to initiate this investigation, and the investigation will probably result in a redesign, and should result in a redesign of the capacity market to take the lessons of the General Court and to comply with the doubts which had been identified and should have been identified. But the Commission challenged this General Court judgment. And in substance, the Commission says that the General Court went too far into the obligation of the Commission and the concept of doubts. The Commission says that they should not take, the judgment should not have taken into account the pre-notification phase, which is before any legal procedure, and that the Commission would be was in a position, although it did not make any investigation on its own, to accept the information given by the state at that time, and that if the situation was complex, novel, or significant, these are not relevant criteria for the General Court to judge about the existence of doubts. And the Commission, of course, is against the argument of Tempus and of the General Court for the identification of the doubts according to all the potential of DSR and the way the Commission examined that. And that, of course, is being discussed now before the Court of Justice. We cannot say more about that. And you will see when the notice of the appeal of the Commission will be published, the exact plea of the Commission, but we cannot say more about this situation. It will take at least 10 to 15 months for the Court of Justice to take a decision, and the timing is difficult. The High Court should decide quickly, but won't decide very quickly probably. The Commission is tempted to decide quickly, but then it could squeeze out all the system by approving immediately the situation at the risk of being challenged again, but on the substance it will be more difficult. And if the Commission decides before the High Court, then the High Court will be bound by a compatibility assessment, and only interest and anticipation of the advantage can be recovered at that time. And of course, if the Court of Justice decides quickly, that could help the process or not. Voilà, Lee.
Thank you very much. Thank you for a very, very lengthy but clear exposition of all the complicated ins and outs that this case is creating. Before we're into question time, but we started a little bit late, and Dan didn't have the opportunity to join earlier. So maybe just a very quick question before we go into the debate, and that is, you hear all the legal controversy surrounding the case, the different investigations that are going on, and the cases that are being brought at different levels. I mean, can you see any appetite for investors in the UK to think that capacity markets could be attractive?
I think so. If you talk to investors, I think it's clear this this doesn't help. This does create a degree of uncertainty in relation to how things will pan out. I think, though, probably most investors are looking at this, and I understand that this may be an anathema to lawyers and followers of the process. But I think most investors are looking at it and seeing that on the part of the UK government and the part of the Commission, there's a desire to kind of to sort this out quickly and in a way which minimises disruption. And I think the majority of investors are sort of are assuming that this will not result in a lot of disorder, that that things will be put back to rights, and the mechanism, potentially in sort of reformed form going forward, will get back on the road reasonably quickly. I think to the extent that there's uncertainty in relation to the capacity mechanism and the sort of perspective on investors on it, actually the wording in the clean energy package around capacity mechanisms being temporary in nature is probably more unsettling. Although equally there's an ongoing question as to whether we will on this island be bound by the terms of that clean energy package. So there's probably there are probably bigger things to concern investors than this, where I think they see a kind of a degree of desire on all of the relevant parties to get it back on the road.
Thank you. That's I think a good summary of where we are from the investor's point of view. Moving a little bit back to some of the legal consequences, if I'm looking at questions from the audience. The fate of the UK, of course, it's difficult to predict. The future of the state aid rules of their application in the UK will very much depend on which road the UK goes down and when. But meanwhile, the judgment is having ripples in other markets, and particularly Poland. And we do have actually quite a lot of questions from the audience on the Polish market and the impact of the Tempus case on the Polish capacity market. Now, Tempus has also filed a suit against the EC, against the Commission, as the Commission approved Polish capacity market mechanism, and there are quite a number of questions about that. So one of the questions is on the admissibility of Tempus. Is it a concerned party? That's a bit of a legal question. So maybe, Jacques, would you like to tackle that?
Yes, okay. With the necessity reserve, because the case has not been yet replied by the Commission, and they've been served with the application, but we are still waiting for the defense, and they will discover our arguments on that, and there is indeed some admissibility questions to clarify. I see on the question that admissibility in the UK case, you mean the EU case concerning the GB capacity market, was based on the notion of concerned party, interested party, in fact, yes, but it's the same in the Polish case. In the Polish case, the case is based on the same type of argumentation, i.e. that the Commission did not and should have initiated the formal investigation procedure and approve it without raising doubts which should have existed. It's exactly the same situation. So Tempus is behaving there as an applicant, claiming that its procedural rights have been violated in its capacity of interested party according to under Article 108.2. They do not claim that they are admissible as individual and directly concerned person, as it would be a test which would be very difficult for any party on the market anyhow. So the admissibility in this case is similar, is probably a bit less direct from person not knowing the detail of the case, but Tempest Energy Germany and Tempest Energy Sweden are connected to Poland by interconnection physically. In fact, there are interconnection, and the design of the capacity market in Poland has an impact on the behavior and on the electricity market in Germany or in Sweden, where operators there can be impacted by the type of design of the capacity market due to this interconnection in Poland. And also, Tempest Energy Germany has a business plan to invest into Poland to make the same type of development of DSR. And to that extent, there is an obvious interest to the lower level of proof, because the interest should not be an interest as a competitor and prove that you are the only one affected by the situation, but only to show that you have an interest, legal interest in the case, because your legal situation in Germany and Sweden will be impacted by the design of the capacity market in Poland because of that interconnection. So to that extent, there is a legal interest, similar to the EU case vis-à-vis the GB capacity market. It's the same situation.
Thank you very much. I think, again, clear. The case law of the court, of course, it's difficult when we look at the way the court dismissed attempts by German producers to challenge the Hinkley decision. Quite an obstacle, I think, quite a high burden to get over. But let's see. Let me move on to a question for Dan from Sarah Bell, who I think has an interest in the case. Given that Sarah is, I believe, the founder of Tempus. So her question is, to what extent we could say that the UK capacity market really does give value for money to consumers, given that demand management, which should be more effective, isn't participating to the full extent. So isn't it a waste of money?
Well, I think the basis on which I said BEIS may consider the mechanism cheap is actually, the price at which it has cleared has been consistently below the level which observers expected. And indeed, if you look at the prices cleared in other capacity markets, and you look at, for example, the recent clearing price in the Irish market, the GB market has seen significantly lower prices and yet new build. Now, some of that was down to the distortions that I referred to earlier, but nevertheless, I think from that perspective, just in absolute terms, relative to what people may have expected at the outset, the government will, I think, consider it good value for money. Whether they would say that including 15-year contracts for DSR would equally represent good value for money, I think is more questionable. And I think to answer that, you have to go back to the reason for 15-year contracts to start with. So when the mechanism was designed, the rationale for the 15-year contracts wasn't that 15-year contracts are a good thing. The argument was actually that by and large, shorter contracts would be better, because in a sense, by signing up to a long-term contract, you're tying customers to pay for 15 years for something which, during the course of those 15 years may well turn out to be on offer more cheaply. It may not, but it may, and there's no obvious reason why, from a policy or an economic perspective, looking at it purely from a customer-centric lens, you would want to tie customers' hands in for those 15 years. The reason that the 15 years was then implemented was essentially on a finance argument that said, if the type of new capacity that we want turns out to involve significant levels of capex, and if that capex needs to secure debt financing, then something which provides a base of secure revenue stream over a longer term period will make achieving the debt finance to start with, and at a low debt cost, more feasible. And indeed, it's the same reason that the UK government and many other governments moved away from certificate mechanisms which put renewables, which put merchant risk on renewables, and sort of moved them towards subsidy schemes which insulate them from merchant price volatility, on the grounds that we need a load of this stuff and it'll be cheaper on a cost of capital basis if we insulate it from volatility. So 15-year contracts, I think, weren't seen as a good thing to start with. They were, I think, it would be more reasonable, certainly from an economic point of view, to see them as kind of a necessary evil to try and support low-cost financing for big capital investments. If DSR does, or if any form of capacity provision, frankly, but DSR included, did not need that significant capital investment, and therefore there weren't the same arguments around securing access and securing low-cost debt, I think if you were going back to the start and designing this, you may well not design those 15-year contracts in, because you would say, well, if you don't need to lock in that stream of revenue for debt finance, we can just buy this stuff as a consumer year by year by year, and the consumer will then take the risk of the prices going up and down. The consumer doesn't need to insulate the investor. So I think to cast the need for demand inclusion in the mechanism as an important factor is right. DSR is participating in the mechanism in increasing amounts. To say that including them on potentially with 15-year contracts would represent necessarily a good deal for the customer, I think, at least economically, is a more doubtful statement.
Lee, yeah, I would like to react to that and comment on a global principle about the aid compatibility assessment. To what Dan said, I mean, no one, in fact, had asked for 15-year contract for DSR. This is not at all on the table, and DSR doesn't need and cannot justify to have 15-year contract, but to have a fair competition and to take in full into account the capital requirements to the extent necessary for them, not 15 years. So that's not the question. But globally, the issue here we have is the minimum aid requirements. An aid is compatible only if the member state can show that the aid is minimum and that the amount of aid granted for the objective is at its minimum. The big problem, which is denounced by DSR and Tempus, is that the potential of DSR had not been taken into account in full. Mistake has been done, no investigation has been done, etc. And if we had taken into account the full potential of DSR, the amount of aid and the capacity market may be justified to a certain extent. Of course, Tempus does not say that there should not be any capacity market, but the design should have been different, because now, simplistically, we can say that without taking into account all the contribution of DSR and others to reduce the instances where there is a need for generation, that means that the aid is too much, it's just too large. An aid which is too large than necessary is an illegal aid, incompatible. Just full stop, it's just that. So it's a simple demonstration to make, of course, on a very technical issue, but it's the test is that. Is the aid, is the money, the billion invested in the capacity market, enough or too big as compared to the contribution by DSR, in particular, which could reduce the need to call on generators, because it would ripe off, as we've seen, it could shed and shift the demand in order to avoid certain blackouts. And the response to that, the Commission has not checked that, and the UK capacity market design has not fairly took that into consideration.
Thank you for that response. I think I can see from the discussion here that there's a lot of commentary here about what's fair, and a concern that the Polish market has perhaps been copying with some risk what the UK was doing. Now, to move to a slightly different question from Vikram, and that is it's a question perhaps that parties in the discussion haven't been able to fully prepare, but they might want to just comment on it rather than give a full answer, because it's a complicated question. We have, of course, another controversial ruling, this time, however, from the Court of Justice, annulling the General Court and annulling the Commission's decision on the German Renewable Energy Act of 2012. Now, in this case, the financing mechanisms at issue were not considered to be aid, and there are many questions now among state aid experts as to whether some capacity market mechanisms that the Commission has looked at and qualified as aid, are they indeed, on the basis of this new ruling, still likely to be classified as aid. Now, rather than perhaps ask for an analysis of whether the French market mechanisms would be aid or not, the question, I think, really takes us to the point, do member states now have a lot more scope to design systems to escape from the rules, from the state aid rules, which means that the new rules under the recast electricity regulation would become the central mechanism to control capacity market mechanisms. And are those rules effective? So maybe first of all, turning to Dan, I know you're familiar with the rules under the recast regulation. Do you think that several commentators here, several participants are arguing there are too many loopholes in the regulation, because we have the cut-off date in the regulation that will allow coal-fired plant to stay on the system? Is there anything you might like to comment there? Whether these rules in themselves.
So I think I speak from the happy point of view that I am completely oblivious to the legal niceties of the ECJ's judgment on EEG. So as an economist, it seems to me to make relatively little sense to exempt aid on that basis. It's, as far as I can see, from a brief review of it, it gives you a perfect opportunity to set up aid in a certain way as to essentially make it exempt, yet you're still shoveling customers' money towards something in a way which, if the man from Mars descended and maybe had a modicum of economic training, he would consider it aid. I think in terms of the rules in the CEP, I'm not actually, whilst I understand the basis for it, I'm not a great fan of the 550 gram threshold in the CEP. I sort of come from the position that you should use instruments, you should use policy interventions sort of in a focused way. If you want something which supports security of supply, you should implement a decent, technologically neutral mechanism to support security of supply, and it should be as non-distortionary as you can make it, subject to having to address practical considerations of financing and such like. If you want to take coal off the system, then or prohibit new coal coming on the system, you should have an emissions performance standard, you should have a coal phase out, and you should do that way. Whilst the realpolitik of European negotiations and it takes you inevitably in that direction. I'm not a big fan of arrangements which mix essentially climate objectives and security of supply objectives. I think the CEP would have been a better piece of legislation had there been separation between those two things.
Yeah, Lee.
Thank you. So I think the answer is, to summarize, you shouldn't muddy the waters. You should choose clearly which set of arguments you're going to allow plant to be kept on the system for, whether it's for reliability or for climate change. A clear distinction, if I can summarize.
Yes.
I think Jacques would like to come in. Which question would you
Yes, I mean,
like to touch
this
on?
question is a specific question for lawyers, and the state aid notion is a legal notion. And paragraph 1, apart from financial issues like market, investor, etc., is a legal notion which is unfortunately reserved to lawyers, because any economic analysis on that legal concept would be vain. Because it's a treaty. The treaty wanted to have a presumption of a notion at certain legal presumption of certain time, and to simplify and to allow to have a very wide notion of the notion of aid. In this case, in an exceptional new case, again, the Court of Justice annulled this General Court judgment on the Yege case, stating that one of the conditions, which is cumulative, the existence of state resources, was not met. That had already been judged at the procès électra, but for other reasons, because the first design of this law in Germany was different and simplistic and simplified at the time. And you have two categories of states, as I always said. You have states which are more intelligent than others, who can avoid legally state aid control if they managed to have a scheme which doesn't have one of the conditions of state aid. No advantage, probably difficult. No imputability, probably difficult since the legislation needed. No distortion of competition, forget it, there will always be. No effect on trade, there will always be. But state of resources, and state resources as qualified by the case law means full control by the state about any fund, private or not, used to finance the scheme. If you manage to trust enough the private operators so that the transfer of the fund which will fund the scheme will not be controlled by the state and will be managed by the private, then you lack that public control. As to the margin, in this EEG case, the Court of Justice said that there was no public control over the fund enough generated by the surcharge in questions. So, of course, in France, it's impossible to imagine, because in France, they tried to do that and they totally missed the point. Of course, in the Van Coller case, it was an usine à gaz, as we say, of control by the administration. The administration was controlling everything from A to Z with sanction, administrative sanction, criminal sanctions, the préfet, the decree, everything. The state was everywhere to control the system. In that situation, you have a control by the state, and it's impossible to avoid state aid control. But some member states could indeed try to, that would be the consequence of the law, try to have a design of a scheme, which is not the case in the UK to what I see, but could be where the control of the state is absent, concerning notably this levy and the financial burden which is provided, and could be just provided by the law without control afterwards of the implementation. So the law is like that, but of course the states cannot but control what they decide. And I think that there will be no probably state who will try to avoid state aid control by taking such a risk, such a management risk, but legally it's possible. So falling outside the scope of stated rules, yes, possible, but in exceptional cases. And you cannot take that case as a sign of a change of case law or as a sign that every scheme will go outside the state rules. No, you just have to have an exceptional situation of lack of control by the state.
Thank you very much. I think that is some guidance then to states as how to assure that they have lack of control. Maybe we have only a few seconds left. I'll turn to Dan for the very last question. And I'm sorry, it's a short question, but it might need a long answer. So I apologize if you're only able to give almost a yes/no answer in the remaining time. But there is a question from Philip Baker to the effect that if we look at the clean energy package, many of the reforms or most of the market reforms that are required by the new package, which hasn't, of course, entered into force yet, but they're already implemented one way or the other in the GB market. So the question is then, would a decision to reinstate capacity market mechanism, is that likely to be consistent?
Yeah, I mean, I think it comes back to that. That comes back to a little bit my point about what where investors are worried going forward is that this interpretation of the phrase temporary. I think in between 2011 and 2014, when the package and the capacity auction was designed and implemented, there was a genuine concern. I remember lots of graphs with sort of plant margins on the UK system falling and real worries about adequacy. At that point in time, I think genuinely the policymakers clearly thought there was a problem. The question now comes: you've also implemented a load of energy-only market changes. What does temporary mean, and how indeed do you get rid of a capacity auction when you have got one? I think in the clean energy package doesn't say that if you've done those things you can't have a capacity auction. I think it would presumably be consistent in that it says it should be temporary, and doing those things presumably means that the period of time for which you should have it is smaller than if you hadn't done those things. I think that does leave you with a question as to how indeed that sort of bit of phrasing will be interpreted, and that I think, as they say, is we'll only know when we get a bit of precedent.
Thank you very much. So precedent is what lawyers like, and I'm sure we can rely on Jacques to encourage the court to make further rulings in this area. I'm afraid we haven't been able to get to all of the questions, but the online debate, I think, has sparked quite a discussion, what we like to call a horizontal discussion among participants, with people answering each other's questions. So I hope that you will join me offline almost in thanking our two speakers for excellent presentations and for their willingness to respond to these very complex questions. And I think there's plenty of issues that we can return to. We'll have many episodes going forward in this legal saga, and I'm sure there are many issues in capacity market mechanism design that will be put up for discussion as we go forward as a result of this legal saga. So thank you again to both Jacques and Dan, and I'd like to thank also the audience for forwarding lots of questions, and the media team in Florence for arranging the debate.